right, and then I am going to make you the host again.
All right.
Fantastic. And then the all lost time is 2.5 hours from right now. So we'll say 12:49.
Great. Thank you so much.
Absolutely. You guys have at it. Good luck.
All right. We are going to call to the docket the estate of Petrillo versus Harper, Martini, and Peony Estates. Are parties ready to proceed?
Your Honor, plaintiff is almost ready to proceed. We do have a witness in an alternate location, and I think he's still trying to get into the meeting, if that's okay.
That is completely fine. Is it okay if we proceed prior to his arrival or her arrival?
That should be fine.
All right. And Counselor Kim, do you represent the plaintiff or defense in this matter?
This is plaintiff, Your Honor.
Okay. All right. Any pretrial matters?
Yes, Your Honor. At this time, the plaintiff would like to make appearances before the court.
You may.
Good morning, Your Honors. My name is Colin Kim, and I, along with my co-counsels, Julia Robertson.
Good morning, Your Honor.
And Lauren Sager, who is currently in the bathroom and will be back momentarily, represent Joey Petrillo as administrator of the estate of Genesis Petrillo. Your Honors, at this time, I would like to direct your attention to stipulation 3 and 4 of the record.
All right. What do those say?
It just states that exhibits 1 through 10. Exhibits 1 through 10 are pre-admitted, and both parties further stipulate that all pre-admitted exhibits may be used or referred to during opening statements.
So that is stipulation 3. What are the others?
Stipulation 4 is that exhibit 11 will follow the same rules as stipulation 3 if Lonnie Paris is called, and the prosecution will be calling Lonnie Paris.
Okay.
Then at this time, Your Honors, the plaintiff is ready to proceed.
Okay. And we've noted that stipulation 3 states that exhibits 1 through 10 are pre-admitted. With that being said, please go through the admission process of each. Obviously, both parties are going to waive objections for those.
Thank you, Your Honor.
Defense counsel, any pretrial matters?
Yes, Your Honor, we'd like to make appearances.
Please do.
Your Honor, good morning. My name is Malika John, and I'm joined here today by my co-counselors, Mr. Kandori
Good morning, Your Honor.
and Ms. Solis.
Good morning, Your Honor.
And today we are advocating on behalf of the defendant of today's trial, Ms. Harper Martini. Your Honor, I just wanted to clarify you wanted us to ask permission before displaying exhibits and demonstratives, right?
Yes, please.
Okay. And we'd also like to verify that you've received a bench book.
Yes, ma'am, we have.
Okay. Your Honor, there has been a pretrial order that was previously ruled in this court. And the defense would like to call for a summary judgment. And I'd like to direct your attention to the September 29th pretrial order regarding that motion, section 1, second paragraph. It states that the parties are admonished that evidence at trial is limited to the battery claim, and any evidence solely related to the negligence per se claim will be excluded. Your Honor, at this time, we'd also like to invoke Rule 615, constructively sequestering all witnesses, save for the party representative. For the purposes of today's trial, that representative will be Ms. Harper Martini for the defense.
Okay. Plaintiff's counsel, do you have a party or party representative that you're representing today?
We do not have a party representative, no, Your Honor.
All right. The bench will grant Rule 615.
And we'd also like to invoke Rule 603, that all witnesses are pre-sworn before trial.
That is also going to be granted.
Furthermore, we'd like to direct your attention to some Midlands case law.
Sure.
First with Burdett v. Copenhaver, which states the elements of civil battery, which are as follows. First, that there must be an act by the defendant. Second, an intent to cause harmful or offensive contact on part of the I'm part of the defendant. And third, that there's harmful or offensive contact to the plaintiff. And then we'd also like to direct your attention to Def and
One
Difer.
second, ma'am.
Oh.
I'm still reading Burdett Copenhagen. Okay, that's my understanding as well. What's the next one?
Def and Difer v. Schroeder.
All right.
This case law is about the burden of proof. It lies solely on the plaintiff, not on the defense. And furthermore, they must prove their case through a preponderance of the evidence.
Yep, that is my understanding as well.
With that, the defense is ready to proceed, Your Honor.
All right, opening for the plaintiff.
Yes, Your Honor. Permission to proceed?
It's your courtroom.
Thank you. Your Honors, opposing counsel, members of the jury, actions have consequences. I stand before you today to tell you of a tragic story, one of an irresponsible father who would not forgive and forget, father who would not allow his son to make his own life choices. This is a father who let his emotions get the best of him and allowed them to push him over the edge. Good morning, Your Honors. My name is Julia Robertson, and I, along with my co-counsels, Lauren Sager and Colin Kim, represent Joey Petrillo, the administrator of the state of Genesis Petrillo. As the plaintiff, we bear the burden of proving, by preponderance of the evidence, that the defendant, Harper Martini, is liable for battery against Genesis Petrillo. The prosecution, or the plaintiff, will call its witnesses. First, you will hear from Angel Rodriguez, a member of the wedding party. He will attest to the fact that Harper did not get along with Genesis and constantly sought out Genesis as a target for Harper's verbal and eventual physical abuse. Second, you will hear from Dr. Kwan, who will report that the ingestion of pesticides used at Peony Estates is dangerous in any quantity. She will tell you that the symptoms Genesis exhibited perfectly matched that of someone who ingested organophosphate poisoning. Lastly, the plaintiff will call Lonnie Paris, who will testify that after personal investigation of the estate, she found further evidence of the tension directed at Genesis by Harper. The defense will call its own witnesses, but none of them will be able to admonish Harper Martini or deny that he did not want Genesis Petrillo out of Casey Soto's life. At the end of this trial, my co-counsel, Lauren Sager, will come before you and ask that you find Harper Martini liable for battery against Genesis Petrillo. Actions have consequences. Thank you.
All right, thank you, Ms. Kim. Opening for the defense.
Yes, Your Honor.
All right, proceed when ready.
May it please the court. Just because an answer is convenient doesn't mean that it's right. Your Honor, opposing counsel, and members of the jury, we are here today because my client, Harper Martini, has been wrongfully accused of battery by the plaintiff. And they came here before you and they told you a story that was convenient, easy to believe, one that would blame the death of Genesis Petrillo on her mother-in-law, Harper Martini. And although we agree that Genesis's death was abrupt and tragic, we know the right answer in today's case is that Harper Martini is not liable for what happened. Now, in that story that the plaintiff just told you, there were key details that they selectively cut out because they know it harms the convenience of their narrative. You'll learn that while the relationship between Ms. Petrillo, her mother-in-law, Ms. Martini, and her fiance, Mr. Soto, was strained, perhaps even intense, it was not the hostile mess that the plaintiff just portrayed it to be. And while they conveniently allege that Ms. Martini killed Genesis to get Genesis out of her son's life, you'll learn that on more than one occasion, Ms. Martini tried for peaceful solutions that would make things right for everyone. You'll learn that even when all options were exhausted, Ms. Martini accepted Genesis as a new member of her family. Testimony will show that on the night before Genesis's wedding, She was not given a toxic bottle of pesticide-laden wine, as the plaintiff alleges, but a gift by Miss Martini, a symbol to turn over a new leaf and start a relationship as a family. Now, as the defense in today's case, we don't bear the burden of proof. That lies solely on the plaintiff's shoulders. They must prove by a preponderance of the evidence that Miss Martini intended to harm Genesis, and that what killed Genesis was a bottle of wine poisoned by Miss Martini. It means that their case doesn't need to be downright impossible. Even if you think that their story is just unlikely, you must find my client not liable for battery. By the end of today's case, it will become clear that that burden is too much for them to bear. Today, the defense will call 3 witnesses who will show the right answer in today's trial. First, the defendant, Harper Martini. Ms. Martini will explain that throughout her long and tenuous relationship with Ms. Petrillo, all she wanted was to bury the hatchet with her son's fiancée, Ms. Petrillo. She'll explain that until Genesis opened that bottle of wine that the plaintiff alleges was laced with pesticides, it was actually safely sealed and unopened. Next, we'll hear from esteemed medical expert, Dr. Cannon. Dr. Cannon will explain how the plaintiff's alleged cause of death for Ms. Petrillo is not as straightforward as it made it seem. In fact, Dr. Cannon will call into question the methods of the plaintiff's expert, Dr. Kwan, shaking the crux of the plaintiff's entire case. And finally, we will call Blair Osborne, the wedding planner for Mr. Soto and Ms. Petrillo's wedding. Mr. Osborne will explain how throughout the entirety of the wedding, Ms. Martini stood by to make sure that everything went smoothly for the new couple, even at Ms. Martini's expense, because she cared about Ms. Petrillo. Your Honor, members of the jury, it'll become clear to you at the end of today's trial that the answer that the plaintiff alleges is just convenient. It has no evidence. It's not right. Pay close attention. Pay attention to how none of their witnesses will claim to have actually seen Ms. Martini put pesticides in Genesis's wine, as they allege. Pay attention to how their conclusion as to how Genesis was killed is actually based on questionable methods. Pay attention to how Ms. Martini's alleged intent for killing Genesis never really lines up with her actions. Pay attention to how throughout the entirety of today's case, the plaintiff will try to make the most convenient story with the least amount of evidence. At the end of today's trial, when all has been said and heard, my co-counsel, Ms. Solis, will appear before you and ask you to find my client not liable for battery. Just because the plaintiff's answer is convenient does not mean that it's right. Thank you.
All right, thank you, Counselor. Does the plaintiff has a case to put on today?
Yes, Your Honor, the plaintiff is ready to call its first witness, Mr. Angel Rodriguez.
All right, Mr. Rodriguez, please take the stand, or Ms. Rodriguez.
I am here.
Okay, welcome, welcome. Plaintiff, you're ready to proceed.
Thank you, Your Honor. Good morning, Mr. Rodriguez. I have a few questions for you this morning, okay?
Okay.
Will you please state your name for the court?
My name is Angel Rodriguez.
And Mr. Rodriguez, what is your occupation?
I'm a kindergarten teacher. I love them kids.
Yeah. And can you tell me why you're here in court today?
One of my best friends, Genesis, died, and I was with her.
And what role did you play in the wedding?
I was a helper. You know, I'm one of their best friends, so I helped them out around a little bit. I remember the night that we were at Rosie and Pedro's, and we were all talking about it, having drinks about where they're going to get married and stuff. It was a good time.
And then did you sense any tension at the wedding as the wedding was being planned?
Objection, Your Honor, leading.
Yeah, Counselor, how is this not a leading question?
Your Honor, this question is open to explanation by the witness. I was simply asking what his rationally based perception was. I can rephrase the question if you would like.
Can you restate what the question was?
How did you sense any tension as the wedding was being planned?
Yeah, it's a close one, but I'm actually going to allow it overruled.
Thank you, Your Honor. All right, Mr. Rodriguez, I'll go ahead and ask you again. Did you sense any tension as the wedding was being planned?
Tension's an understatement for what was going on there. You see, Casey, Genesis, and Harper all had beef together, and like there's a lot of tension, as you say, everywhere. Casey arguing with Harper, Harper arguing with Genesis, Genesis arguing with Casey. Instead of a love triangle, I feel like that was a hate triangle right there.
Can you explain what happened at the rehearsal dinner?
Of course I can. So, we're at the rehearsal, all kind of just enjoying our dinner and everything. Then Casey gets up and he does his speech. I'm kind of already drinking, so I don't really remember what it was. And then, Genesis gets up. Oh, Genesis, my girl, that's my homie right there, gave this lovely speech. I loved her so much. And then Harper gets up and he just gives this whack speech. He called Genesis a problem child. I was like, why you gotta talk down to my girl like that? Like, Harper's just giving an off vibe the whole night.
Did you see anything else that involved the tension between Miss Martini and Genesis?
Yeah, throughout that whole night. So that was the dinner. And throughout that whole night, I saw Genesis and Harper. They got into it a little bit. And then, like, when I asked Genesis what that was about, he was just like, stay away from
Your Honor,
Harper.
hearsay.
To which statement are you referring to?
The witness is about to explain what Genesis specifically said to him during the night of the rehearsal dinner, and that is hearsay.
All right, Ms. Robinson, why is this not hearsay or an exception to hearsay?
Your Honor, Mr. Rodriguez hasn't testified to any specific statement that Ms. Petrillo has made. In addition, this is not being offered for the truth of the matter asserted.
Let's take these one by one. To start, is there going to be a statement elicited? Because if so, it's better to stop the bell before it rings.
No, Your Honor, there is not a specific statement being offered today.
Okay. Well, I will overrule it for now. Attorney Solis, if you believe that a statement has been elicited, and this, at faith basis that Counselor Robertson's saying is incorrect, please re-raise your objection.
Yes, Your Honor.
Thank you, Your Honor. Ms. Rodriguez, I'll go ahead and ask you that question one more time. Did you see anything else involving the tension between Miss Martini and Genesis?
Yeah, and there's another moment. I was going out to the kitchen. I ran into Harper, and he had this like weird bottle. I think it was pesticide with him, and I was like, "Yo, what are you using that for?" And he was like, "Oh, I'm just gonna get rid of Genesis. She's such a pest." And I was like, he laughed about it, but I didn't really laugh because that was my homegirl. I kind of felt uncomfortable about it, but I was like, whatever. And so I kind of went about the night, and then throughout the night, my boy Harper, he got this Carl wine. And he gave it to Genesis, and like it really shocked everyone that night because we were like, "Yo, what's he doing?" And he gave it to Genesis as like, I don't know what he was doing, but like, it seemed like he was trying to apologize or something, and like it really surprised everyone.
And what happened after dinner?
After dinner, me and a few buddies and Genesis, we all went to go drink at a bar and stuff. Genesis ordered some tequila shots, and we were all having a good time. I'm talking to my boy Drew, and we all took the shots. I noticed that Genesis actually didn't take a tequila shot. And so I found that pretty peculiar because me and her are usually like drinking buddies. We go shot to shot. And she didn't take a shot. And then, I look over again and she's knocked out. Genesis knocked out, gone. And I'm like, well, let me help the homegirl up. And I go and try to take her to the bedroom. And something was weird when I picked her up was like her breath did not smell like alcohol. That was really weird.
Did you see Miss Petrillo drink the wine?
So she drank the Carl wine. She she loved that joint. She gave me a sip, and I was like, this does not taste good whatsoever. But she loved it. She was drinking the Carl wine, and like I think she drank almost half the bottle, not the entire bottle.
And Mr. Rodriguez, why did you call 911 later that evening?
So as I'm taking Genesis up to her bedroom, she starts vomiting everywhere, and I'm trying to give her water, and not even the water's laying her in her stomach, and she's vomiting everywhere. And I'm like, yo, my girl's gonna die. Like, what's going on? And I'm like super panicked. Her skin is flushed. She's super pale. I'm like, oh my gosh, what's gonna happen? And the last word she told me was 911. And I was like, I gotta call 911. And so I called 911, and I got on the EMTs with her, and I took her to the hospital.
What happened after Genesis went to the hospital?
So she kind of entered this coma state, and I thought she was gonna come out of it, be fine. And then around like 8 a.m., maybe 9, I got the news that she passed away. And I was like, well, now I need to go back and I need to go tell Casey what happened. I was really, my girl just died, man. It was really hard. So it was hard.
And then did you see Harper that morning?
Yeah, I ran into Harper as I'm going to try to get Casey. And there's something off about this incident was that as I'm going, Harper speaks to me first, and I'm a little hungover, so I'm kind of slow to speak and stuff. And he speaks to me. He goes, "Oh no, Genesis is poisoned. That's terrible," and then runs off. And I was like, "How did you know she was poisoned when I just got here to tell her that she passed away?" And it really threw me off.
Thank you for your time, Mr. Rodriguez. Please answer any questions that the opposing counsel has for you. No further questions, Your Honor.
All right, thank you. Attorney Solis, you can proceed when ready.
Yes, Your Honor. Good morning, Mr. Rodriguez.
Good morning.
Now, I'd like to start with your relationship with Mrs. Petrillo. You guys have been best friends for about 6 years, correct?
Yes, man, we're as thick as thieves.
Yeah, and she was considered your best friend, right?
Yes, ma'am.
And majority of the information you got regarding the relationship between Genesis and Mrs. Martini was from Genesis, right?
Correct.
In fact, you never even met Mrs. Martini except maybe 2 times.
Yeah, but each incident was just like, I didn't really like her, but yeah, yes, you are correct. Yep.
So you never witnessed the true relationship between Mrs. Martini and Genesis Petrillo.
Yes, ma'am. Yep.
Okay. And I'd like to talk about the night of the rehearsal dinner. Let's move to the rehearsal dinner. You stated that you kind of were already drinking during the speeches, so you couldn't exactly remember what Casey said, correct?
Correct.
However, Mrs. Martini gave her speech after Casey that night, didn't she?
Yes, ma'am.
And the events that happened to Mrs. Petrillo happened after that speech as well?
You are correct, yeah.
So after you continued drinking for multiple hours throughout that night, you were able to remember the end of the night, but not the beginning?
I'm not a light drinker, I'm able to hold my liquor and everything. So yeah, I would say I'm able to remember some stuff, yeah.
Now, you also stated that you looked over at Mrs. Petrillo and realized that she was extremely out of it at one point, correct?
Yes, she was. She was shaking underneath the table. I was like really worried.
But you allowed her to drink for another hour after that, didn't you, Mr. Rodriguez?
Hey, it's her call. I'm not gonna be the one to stop her from drinking. We always go drinking.
But you stated on direct that you took her right upstairs after you realized this, didn't you?
I took her upstairs after she passed out at the bar.
After you realized that Mrs. Petrillo was passed out and still was struggling to speak, you allowed her to drink for another hour, Mr. Rodriguez, right?
No, that's not what happened.
You didn't realize that Mrs. Petrillo was completely out of it and allowed her to keep drinking?
Objection asked and answered. Your Honor, may I be heard?
Sure.
I feel as though my witness has already made it clear that Miss Petrillo was drinking, and then when she passed out, he took her upstairs.
Your Honor,
Well,
if I may.
Yes, you can.
I do believe that the witness has actually answered the question 2 different ways both times, so I'm simply trying to find a clear answer throughout this testimony.
I'm inclined to agree. I think that, defense counsel has every right to make sure that the answer that's elicited is clear. So I think to give the witness one opportunity to answer the question in a way that is clear for the members of the jury is perfectly appropriate. If it goes beyond that, please re-raise the objection.
Okay, Mr. Rodriguez, I'll break this down. So you witnessed that Mrs. Petrillo was struggling to speak, correct?
Correct, yes.
And you witnessed that she was incapable of walking across the floor to the bar by herself, correct?
Yes, ma'am.
And after those 2 events happened, you continued to allow her to drink for 2 hours, correct? For an hour, correct?
Yes.
Until she then passed out and you had to drag her up the stairs, correct?
Yeah.
Now, you also stated that during the rehearsal dinner, she gave you a drink of the Cara wine.
Yes. Yeah. I did not like the taste of that. That did not taste good.
But you didn't get sick from the Cara wine, did you, Mr. Rodriguez?
No, I did not. Well, that's because I didn't swallow anything. I spit it right out before I could let it go down. It tasted disgusting.
You still did not face any adverse effects from putting the Cara wine in your mouth, correct?
That is correct.
Okay, no further questions, Your Honor.
All right, anything further for this witness?
No, Your Honor, I asked that he be allowed to step down.
All right, Mr. Rodriguez, you are excused. Plaintiff counsel, are you going to be calling any other witnesses in today's trial?
Yes, Your Honor. Give me one moment to confer with co-counsel.
Good morning, Your Honor. The plaintiff would like to call Dr. Jameen Kwan to the stand.
All right, Dr. Kwan, you are sworn in already. Doctor, I'm glad to see you following CDC guidelines.
Thank
All right, and plaintiff counsel, please proceed with your direct whenever you're ready.
All right. All right. Dr. Kwan, please state your name for the court.
My name is Dr. Jameen Kwan.
And what is your educational background?
I received my BS in biology with a minor in chemistry from the Georgia Institute of Technology, and then went on to get my medical degree at the University of North Carolina at Chapel Hill. I also completed my residency at Emory's Department of Emergency Medicine, and then a fellowship in medical toxicology under Dr. G.T. Seaver.
Very impressive, Dr. Kwan. Have you published any articles in your field?
Yes, I have published several articles. My most recent one is called A Woman's Weapon or an Unfortunate Accident, an analysis of US poisoning cases from the year 2000 to 2015, which was published in the Journal of the American Medical Association in 2016.
And what is the nature of your current occupation?
I currently work as the chief emergency physician at River Valley Hospital in Midlands.
All right, and what does your position entail?
My position requires me to quickly and accurately diagnose cases of patients who enter the emergency room so that they can receive the best care possible. And I lead a team of doctors and nurses. However, I'm the one in charge ordering tests, making diagnoses, and deciding on the course of treatment for each patient.
Okay. Do you have a specific specialty?
Yes, I do. I specialize in toxicology. And whenever suspected poisoning cases come in, I'm the one who treats that patient.
Dr. Kwan, when did you first encounter Ms. Petrillo?
Ms. Petrillo was brought into the hospital by her friend Angel Rodriguez, who reported that Petrillo had been at a party.
And what
Your Honor, hearsay.
To which statement?
Asked her that Genesis had been at a party previously and that she heard from Angel Rodriguez as such.
All right, Counselor Seeger, how is this not hearsay, or why is it an exception?
Yes, Your Honor. So the statement is just providing background for the situation that was going on with the doctor. It's something that she witnessed, and it wasn't a statement that was offered for the truth of the matter asserted.
So if it's not being offered for the truth of the matter asserted, what is it being offered for?
Just for foundation for why Genesis was at the hospital that day.
Unfortunately, the rules of evidence does not provide for that. Attorney Candery, do you have anything else to say on this matter?
Yes, Your Honor. Simply that as even if it's for foundation, opposing counsel just said it's for background, and they're using the truth of the matter for both foundation and background. Therefore, it is inadmissible hearsay.
All right, Ms. Seeger, I'll give you the last word if you have anything else to say.
No, Your Honor. We can go ahead and move on to the next question.
Yeah, I'm going to sustain the objection as Midland's rules of evidence does not account for background or foundation as an exception or a negation of hearsay.
I ask that any testimony given to that question be stricken from the record.
So stricken.
All right. Dr. Kwan, what was your initial diagnosis?
Initially, I expected hers to be a case of alcohol poisoning.
Okay. And at what point did you suspect that you might be wrong?
When I completed my full examination.
What stood out to you during this examination?
Three things. First, her pupils were severely contracted, whereas alcohol poisoning usually causes dilated pupils. And she was also tearing excessively.
Okay, what was the second?
She exhibited involuntary muscle twitching and incontinence, which are not used symptoms of alcohol poisoning.
And the third?
Finally, Petrio's pulse was slowed rather than rapid.
Okay. What did you begin to suspect was the actual cause of Ms. Petrio's symptoms?
I began to suspect organophosphate, which is a poison that is commonly used as an insecticide to be cause of Petrio's symptoms.
Okay. Did you order any additional tests?
Yes, I ordered a toxins and poisons analysis test in addition to a toxicology report.
Okay. And why did you believe that organophosphate was the poison involved?
Organophosphates are the only pesticides commonly used in Midlands that can cause pupils to contract.
Okay. Is this poison detectable in the bloodstream?
No, it is not detectable in the bloodstream because it goes through.
Objection, Your Honor, leading.
All right, so is the poison detectable in the bloodstream was the question, correct?
Yes.
Yes, Your Honor.
Yeah, I'm gonna overrule.
Thank you, Your Honor. I'll ask the question again, Dr. Kwan. Is this poison detectable in the bloodstream?
No, it is not detectable in the bloodstream because it goes through hydrolysis in the liver very rapidly. And there's no simple blood test to determine the levels of organophosphates the patient has absorbed.
Okay, so how do laboratory analysts find out the levels in the bloodstream instead?
They look for indicators such as low acetylcholinesterase levels, which is a telltale sign of pesticide exposure. It is so closely related with organophosphate pesticide that doctors can use it to conclusively diagnose organophosphate poisoning.
Okay. How much organophosphate poisoning would one have to come into contact with for it to be potentially deadly?
While it is not currently possible to determine the exact amount of organophosphate which has been ingested, any suspected ingestion of the poison is potentially deadly. And there have been many cases of people being hospitalized and even killed from simply ingesting only the amount remaining on food or cooking spray.
In what ways can a person be poisoned by organophosphate?
There's 3 ways: absorption through the skin, inhalation, as well as oral ingestion.
Okay, and how do you suspect that Ms. Petrio came into contact with this poison?
Ms. Petrio likely ingested the poison.
Okay, why do you believe this to be the case?
She did not report any skin contact, and there was no outward evidence of such contact, and the order and time frame in which her symptoms appeared were inconsistent with either absorption or inhalation.
What is the natural progression of organophosphate poisoning by ingestion?
Upon ingestion, a person will begin to experience digestive symptoms, including nausea and vomiting. And then next, the nervous system is affected, where symptoms such as excessive sweating, difficulty walking, slowed breathing, contracted pupils, and excessive tearing will begin to appear. And then in severe cases, one can experience muscle spasms and incontinence, seizures, and respiratory constriction. And these final symptoms often lead to death if not treated in time.
And did you administer an antidote?
Yes, I did.
All right, what happened next?
I asked the lab to run an acetylcholinesterase test and told them to prioritize this test and the organophosphate test.
What did you note as Ms. Petrio's preliminary cause of death?
Respiratory failure due to pesticide poisoning. She experienced a coughing fit and a seizure and then fell into a coma, which she never woke up from.
What reason did you have to believe that organophosphate poisoning led to Ms. Petrio's death prior to receiving your test results back?
The progression of Petrio's symptoms perfectly matched the expected progression of pesticide poisoning case. There is digestive symptoms followed by sweating, contracted pupils, and a slowed heartbeat, and finally nervous system symptoms, including involuntary muscle movement, seizures, and unconsciousness leading to death.
Okay. And what were the results of these tests when they did come back?
They revealed extremely low acetylcholinesterase levels, and an organophosphate pesticide was present in Petrio's blood. Results from testing Petrio's vomit revealed that she had indeed ingested wine, and the contents of her stomach also contained the organophosphate pesticide.
And what was her blood alcohol concentration?
Her blood alcohol level was 0.16%.
Why does this matter?
a blood alcohol level of 0.16% is generally enough to cause significant impairment of motor function, slurred speech, excessive sweating, and often can cause nausea and vomiting, but it's extremely unlikely to cause death, seizures, or other serious symptoms like those exhibited by Petrillo.
Interesting. How do organophosphate and alcohol interact when ingested together?
The two often interact negatively, and this can cause the pesticide symptoms to be more severe and exaggerated.
All right. And finally, Dr. Kwan, what is your expert conclusion?
I can say to a reasonable degree of scientific certainty that Genesis Petrillo ingested wine contaminated with an organophosphate in the evening of June 7th, 2019, and that this pesticide is what ultimately caused her death.
Thank you,
Objection,
Dr.
Your Honor. Improper opinion testimony, if I may be heard.
Yeah, what rule is this?
Rule 702, Your Honor.
702 doesn't state that. It states lack of foundation.
Excuse me, Your Honor. I believe it's Rule 704, I think.
Well, no. 702 pertains to experts, and I believe
Experts,
it's what you're
right.
attempting
Improper
to
opinion
say.
testimony that they haven't laid all 4 prongs, A, B, C, and D, for expert, although they
Okay.
have laid the foundation for her expertise and knowledge in the field. They have not shown, as per the prongs, that she has applied reliable methods in today's case, that these methods are in any way verified and used in the field. Therefore, I believe that her ultimate conclusion is not admissible in today's case.
Plaintiff counsel.
Yes, Your Honor. So in the beginning of Dr. Kwan's testimony, we referenced the expert's scientific, technical knowledge on the specific subject, as well as that her methods were reliable based upon, the question, have you published any articles in your field? And she answered and referenced one specific article, which was published by the Journal of American Medical Association in 2016, and was sufficiently peer-reviewed, therefore solidifying the conclusion that her methods were indeed reliable.
Your Honor, if it may be heard.
Not right now. So the scholarly article doesn't matter because that's under prong A, and opposing counsel was suggesting that we haven't heard anything about the method. So what testimony about the doctor's method specifically was elicited?
Yes, Your Honor. I questioned the doctor about, what she suspected first as her initial diagnosis based upon the symptoms, and then after that, how she ran a full examination. And it was determined to conclude a different conclusion than she had first stated. And these methods are considered to be reliable based upon the fact that that Dr. Kwan is a respected member at this hospital. She has sufficient training involved.
Her respect in the hospital is irrelevant to whether her method is reliable. So again, just to direct you back to the concern, what is the specific method that's being used?
Your Honor, may I confer with my co-counsel?
Please do.
Thank you, Your Honor, for the brief moment. My line of questioning was specifically targeted towards her methods in how she treated the patient and how she determined her diagnoses based upon the specific symptoms. And these methods were determined to be reliable based upon her expert scientific knowledge that was that was laid out in stipulations A and B of Rule 702 and sufficiently testified to in the beginning of her testimony.
All right. Now, defense counsel, if you want opportunity to be heard on that.
Yes, Your Honor. Again, we haven't heard as to exactly what those methods are. Making a diagnosis is a conclusion. That's not exactly a method. How she proceeded going about her test, and she never compared this as to whether this is a normal case and what procedures she specifically took for the case of Genesis Petrillo. These are not methods. These are merely conclusions.
Yeah. I'll give plaintiff counsel one more opportunity.
Your Honor, may I ask a follow-up question to my witness in order to lay more foundation for opposing counsel?
Sure. I mean, at that point, I would have to sustain the objection.
Okay. I apologize, Your Honor. Let me just once again state for the purpose of this objection to state that the specific methods that were testified to are, when during Dr. Kwan's testimony were that she took a preliminary examination of the patient in the emergency room and assessed her symptoms. And then upon that, she made the primary diagnosis that the patient was suffering from alcohol poisoning and then admitted her to the hospital. And then after that, she conducted a full examination in which she looked at further symptoms and completed testing, including a full toxicology report and analysis. She drew blood, she tested the contents of her stomach, and they all came back to sufficiently prove that Ms. Petrillo's death was the cause of organophosphate poisoning.
Okay. All right. So that makes a lot more sense, counselor, that those are the methods. How are those methods under Rule 702C reliable? Because at this point, I think that you've sufficiently covered A, B, and D under Rule 702. However, under 702C, we now need to hear how those methods are reliable and specifically what testimony has been elicited from the doctor to suggest it.
Yes, Your Honor. May I confer with my co-counsel real quickly?
Yes. I would suggest that everyone takes a look at the Midlands case law as well.
Yes, Your Honor.
Your Honor, if I may, I think the only thing that we're missing here is for the expert witness to testify that her methods are indeed reliable. We've already established, as you said, prongs A, B, and D of this rule, and her articles, her work being peer-reviewed, speaks to the fact that her methods that she's using should be reliable in the scientific community. And if she could just testify, I'll ask a question for opposing counsel's benefit, that her methods are indeed reliable.
Okay, with that, we're going to tentatively overrule the objection and let you ask the question on the good faith basis that we're going to get that testimony out from Dr. Kwan.
Yes.
Right. Okay. And then, Attorney Kanduri, if you believe that this good faith basis has not been maintained, please re-raise the objection.
Yes, Your Honor.
Thank you, Your Honor. Dr. Kwan, would you please explain how indeed your methods that you applied in this case are reliable?
Yes. Well, I am always particularly thorough with my examinations. I find that completing both a toxicology report, a blood test, as well as other laboratory analysis, I find that my examination was very thorough and as well as reliable.
And is this common practice, Dr. Kwan?
Yes, yes, it is.
Thank you. No further questions, Your Honor.
Defense counsel, do you want to re-raise the objection at this time?
No, Your Honor.
All right, it'll stay overruled. All the testimony is in. Defense, you can proceed with your cross-examination whenever you're ready.
Yes, Your Honor. Good morning, Dr. Kwan.
Good morning.
Now, Dr. Kwan, your first step in examining a patient is to understand what's wrong with them, right?
Correct.
And Mr. Petrillo, he showed many symptoms of something being wrong with him when you first examined him, right?
Yes,
He was nauseous,
that's correct.
vomiting,
Yes.
he had slurred speech,
Yes,
stomach pain,
yes, that is also correct.
and he even smelled of wine, right?
Yes,
And it's all of these symptoms that led you to believe that initially he was suffering from alcohol poisoning, correct?
yes, that is correct.
Now, you later changed your opinion, right?
Yes,
And you also received lab results corroborating that?
yes, I did.
But these lab results never actually measured whether or not there was pesticide in Genesis's body directly, right?
These lab results did reveal that organophosphate poison or pesticide was present.
But they could not measure the exact level, could they?
They could not.
Right, and they only measure the level of acetylcholinesterase, an enzyme that is inhibited by organophosphates, right?
Yes, the organophosphate does that. Organophosphate pesticide is often related to, heavily related to low acetylcholinesterase levels, almost telltale sign of that.
But isn't it true that other factors, such as conditions that are chronic, can also affect acetylcholinesterase level?
Yes, but not symptoms that Petrillo had.
But specifically to acetylcholinesterase levels, chronic symptoms, chronic conditions do affect acetylcholinesterase levels, yes?
Yes,
And you don't have access to Genesis's medical history,
no, I do not.
so you can't say with certainty that there was no other cause for acetylcholinesterase activity, right?
I cannot.
Now, ingestion is not the only way to absorb organophosphates, right?
No, it is not. There's
Both
also,
inhalation.
yes, inhalation and absorption through the skin.
And you don't know exactly where Genesis was on P&E Estate's property, right?
No, I do not.
You don't know exactly where she could have come into contact with these pesticides?
No, not exactly, no.
Now, I'd like to direct your attention to Genesis's treatment. You administered the antidote as soon as you believed that Genesis was suffering from organophosphate poisoning, right?
Correct.
Dr. Kwan, did your antidote for organophosphates work?
Yes,
Dr. Kwan, is it your testimony today that your antidote for organophosphates were able to save Genesis Petrillo?
not in Genesis Petrillo's case.
So the antidote you administered for organophosphates did not work, correct?
No, that is correct. They did not work.
Okay. And you said the cause of Genesis Petrillo's death was failure to breathe properly, right?
Correct.
But despite her difficulty breathing, you did not administer a respirator, did you?
No, I did not.
Thank you, Your Honor. No further questions.
All right. With that, we are going to, or I guess, does plaintiff have any other witnesses they want to call?
Your Honor, is there an opportunity for any redirect?
Oh, absolutely. Thank you so much for correcting me on that. Redirect is completely fine. If Dr. Kwan can retake the stand, and we will proceed when you're ready.
Dr. Kwan, I just have a few more questions for you. First, if you had sufficient reason to believe that something else may have been the cause of Ms. Petrio's symptoms and the low acetylcholinesterase levels, would you have tested for other things?
Yes.
But time was of the essence because you suspected it to be a poisoning case, correct?
Yes, it was.
Objection are leading.
That's sustained.
Okay, Your Honor, I will rephrase my question. Dr. Kwan, did you have sufficient time such that you could have tested for other things and not be worried about Ms. Petrio's well-being?
No, there wasn't.
Objection are leading.
Close, but I'm going to overrule it.
Yes, Your Honor.
Thank you, Your Honor. And finally, Dr. Kwan, how closely correlated are low acetylcholinesterase levels to the presence of organophosphate poisoning in someone's system?
Highly correlated.
Thank you. No further questions, Your Honor.
All right,
We have
any
a witness.
recross?
No recross, Your Honor.
All right. Now the witness can leave the stand. Thank you for correcting me on the redirect. And does plaintiff have any other witnesses to call this after this morning?
Yes, my co-counsel will now call Lonnie Peras to the stand.
All right, we can have that witness take the stand. All right.
Did you change my name already? Okay. Ms. Paris, are you there?
Yes, I'm here.
All right, whenever you're ready, plaintiff.
Thank you, Your Honor. Can you please state your name for the court?
My name is Lonnie Paris.
And what do you do for a living, Ms. Paris?
Well, I'm a journalist by trade, but I'm an environmentalist at heart, and I believe it is my job to expose the dark corporate secrets of America that are harming the environment.
Thank you. And how did you first hear about Peony Estates?
Well, I first heard about the estates when I was a journalist working for the corporation Blitz News Network. I specialized in undercover journalism. And while I was working there, I received a tip that Peony Estates had several health code violations. So I decided to maybe go investigate. But it first got pushed onto the back burner because I had other more important work at the time.
All right, let's talk about your first visit to Peony Estates. When was that?
It was 2 years after I got the tip, so around July of 2018. I was working freelance at the time due to getting let go from BNN, but I did not get let go because I was a bad investigative journalist. I got let go because they had budgetary issues.
And what did you find when you were investigating?
Well, I examined the public areas of the winery, and I didn't really find anything out of the ordinary. But I did see that the estates had a tour that they had every Monday, Tuesday, and Thursday. And there was a public tour that I could take, and I knew that I had to go. And I figured that it was in my best interest to figure out if there were any undercover things that the estates was hiding.
Did you end up going on these guided tours?
I did. And each time I used a different disguise. It was so much fun. The tour was very informative, and I learned a lot about the winemaking process. While I was on the tour, I saw an employees only section, and I decided to sneak in.
And what did you see in the employees only section?
Well, I found the winery's bottling area.
And what did you find in the bottling area?
I found some discarded canisters of pesticides, which I thought was kind of interesting since it was in the bottling area, and they had a label titled "Bug Off" on them, and they were scattered in the back of the room, but they did appear to be unopened and new.
How many times did you return to Peony Estates?
I went back once again on May 6th. I went again 2 days later on May 8th. I visited on May 30th, and the last time I visited was on June 7th.
Interesting. What did you learn on your third trip, the one that you took on May 30th?
Well, that day was so fun. I went by the disguise of that my name was Topaz Cash. It was so fun. I had my little teal outfit on. I'm wearing the sweater that I actually wore today. It was just a great time. And I had some jewelry. I really liked my Topaz character. I thought she was fabulous. But I learned that Casey was getting married on June 8th of 2019. And then that day, I knew that I could use the wedding prep as cover to go back and infiltrate the estates again. So it'd be a really good opportunity for me to take on a new disguise. And I was able to look around the employees only section again. And I do recall seeing Harper Martini meeting with someone very specific about a storage shed, but I could not tell you who that person was. I specifically remember seeing Harper hand over an envelope to the person that she was talking to by the storage shed.
Were there any indications of who that other person could have been?
Yes, the person had the same height and build of Genesis Petrillo, but I cannot confirm nor deny that that was in fact her.
Thank you. And what was the last visit to Peony Estate like?
Well, I returned once again to the winery on June 7th as caterer for the wedding, which was so much fun. And it was the rehearsal dinner, so it was pretty easy to sneak around.
Did you sneak around that day at all?
I didn't go anywhere new, no. I just went back to the same employees only section that I had been going times before.
And what did you see this time?
Well, I went back to the bottling area again, and I found a single bottle of 2019 car wine sitting all by itself on the shelf. And I got to think about it, and I think it was the same bottle of wine that I saw on my visit to May 8th of 2019. And it seemed very, very odd to me. So I was going to look more into it.
Objection, speculation.
To which statement?
The statement saying that I saw a bottle of wine and I believe it was the same one from the month before, like that statement.
Okay. Attorney Kim, why is this not speculative?
Your Honor, it was based on prior experience. She had seen it there before, and it's her rationally based perception today that that was the same bottle of car wine.
Okay. I'm going to overrule.
Thank you, Your Honor.
No need to thank me.
So you could you repeat the last bit of that question?
Yeah, so after I saw the bottle of wine sitting by itself, I was gonna go look more into it, but then I heard some shouting, so I decided that took precedent over me going to see the wine.
And who was shouting?
Well, at first I didn't know, so I decided that I needed to get a little bit closer. And then I realized it was only between two people because I only heard two voices. And one voice I recognized, and it was the voice of Harper Martini. And I recognized her voice because I had heard her voice prior on the tours when she was speaking to other people that I had taken multiple times. And I could not identify the other voice, but it did sound very familiar.
And what happened after that?
Well, I got to the point where I could see them. And the person arguing with Harper had left at that point, so I can't tell you who was arguing with Harper. But I noticed that there was a crumpled up envelope on the floor, so I decided to get closer. And I opened it and I took a picture of the letter and then I put it back how I found it so it didn't seem suspicious, which I think was a pretty smart move on my part.
Indeed. What did you see after you put the envelope back?
Well, Harper came back, picked up the envelope from the ground, and then threw it into the furnace and it burned it. And then I followed Harper, who went back to the bottling area where he picked up the 2019 bottle of car wine from the shelf, which I thought was super odd.
Did you notice anything else while you were investigating?
Yes, I did actually. There was an empty canister lying next to the bottling station, and the label was ripped off of it, but it looked exactly like the canister of bug off pesticides that I had seen before.
Did anything else happen that night?
Well, they were giving their toast speeches in Genesis. Oh, she just gave a lovely, lovely speech. It was so good. And when she was giving her speech, that was when I realized that she was the other voice that was yelling with Harper when I had heard them before.
And were you able to talk to Genesis at all?
Not that night. I decided not to talk to her because I thought I could talk to her the next day at the wedding, but then I did not get the chance to. And it's very sad. It hurts my heart a lot.
Why is that?
Well, I got to the wedding the next morning around 8:30, and I found out that Genesis had passed and Angel Rodriguez arrived in a disheveled state. And so then I had to go to the hospital to see what was going on.
And how did you feel after hearing that Genesis had passed?
Well, I was just simply devastated, and I was so mad at myself because I knew that had I told someone what I thought was happening, I could have probably prevented her death. It still gets me every time, and I don't even like talking about it. It makes me so sad.
Thank you, Your Honors. No further questions.
All right, cross-examination.
Good morning, Ms. Paris.
Morning.
Now, you first received Danny Francasio's tip in 2016, correct?
That is correct.
But you didn't pursue this tip until 2018, right?
That is correct.
And by the time you did pursue this tip, you were unemployed, correct?
That is correct.
And you were hoping that if this story went well, it could rejuvenate your journalism career, correct?
Not entirely. I wouldn't say that. I just knew that it was a story that I needed to investigate. I wasn't really looking further ahead at the time for another career. I was just looking to see what I could get out of this one.
Ms. Paris, you thought that this story, if it did well, would help your journalism career, correct?
I mean, I guess, but like I said, I wasn't really thinking about that at that specific time.
Is that a yes or no, Ms. Paris?
No.
Ms. Paris, it is your testimony today that you did not think if the story did well, it would be good for your journalism career.
I did not state that.
Ms. Paris, do you remember writing an affidavit?
Yes.
And you're aware that you had time up until today to change anything if you thought anything, if you misremembered anything or thought anything was worth adding?
Yes.
And you would recognize if I showed you that in court today?
Yes.
Your Honor, permission to approach opposing counsel and the witness with their affidavit.
Yes, is it going to be screen shared?
Yes, I'll have to open it up very quickly.
Take your time.
Thank you.
Your Honor, I would like to object to the fact that this is not relevant to the case of the matter asserted.
What is not relevant?
The fact that Ms. Paris thought that whether or not this story would rejuvenate her career is relevant to whether or not Ms. Petrio's death was battery or not.
Your Honor, if I may respond.
You may.
I believe that bias in the witness is always relevant.
I agree. It is overruled. Any other objections pertaining to this, I guess, impeachment that's going to occur?
No, Your Honor.
I believe it is line 37. Okay. Ms. Paris, on line 36 through 37, may you read silently as I read out loud. I guess part of me was hoping that if I actually found something, I might be able to rejuvenate my journalism career. Okay. Did I read that correctly?
Yes.
Which line was that? Sorry, I'm lost.
36 through 37, Your Honor.
Thank you.
Okay. With that, let us move on. Ms. Paris, during one of your investigations, you went into the bottling area, correct?
Yes.
And you heard yelling.
Yes, that is correct.
You decided to investigate and you saw two people shouting at one another.
Yes.
You recognized one was Harper Martini,
Yes.
but you could not identify the other voice.
Correct.
In fact, when you went to get closer, investigate, you couldn't even tell what they were arguing about in the first place, correct?
That is correct.
And you had no idea what the context of this argument was, did you?
That is correct.
Okay. And furthermore, during one of your investigations, you saw a bottle of Cara wine on the shelf of the bottling area, correct?
That is correct.
And later on, you saw a bottle of Cara wine being given to Genesis Petrillo, correct?
That is correct, yes.
But Ms. Paris, you don't know how many bottles of Cara wine were on Peony Estates, do you?
I do not at the time, no.
And it is very possible that the one you saw on the shelf was disposed of.
I guess that's possible.
Is that a yes or no, Ms. Paris?
Yes.
Especially given that there had been a month's period between the first time you saw it and another time you saw a bottle of Cara wine.
Yes, that is correct.
So it is entirely possible that the bottle of wine you saw on the shelf was not the same one that was given to Genesis Petrillo.
Objection, Your Honor. Asked and answered.
Response?
I didn't, the first time I asked a question saying that asking Miss Paris if she believed that the bottle of wine was it was possible that the bottle of wine was disposed of. And now I'm asking if it's possible that the bottle of wine was not the same bottle.
Yeah, I think it's a different question. I'm going to overrule.
It is entirely possible that the bottle of wine you saw on the shelf is not the same as the bottle of wine that was given to Ms. Genesis Petrillo.
Yes, that is correct.
Thank you. No further questions, Your Honor.
All right, any redirect?
Yes, Your Honor, one quick question. Ms. Paris, what is your overall goal as a journalist?
Well, my overall goal is to just make sure that everybody is safe and that there are no environmental harms to America or anything going on with the environment. I just really want to provide safety to the people.
Objection, relevance.
Country.
Counselor, what's the relevance to the statement?
Your Honor, I just want, if I may proffer, Ms. Paris is just saying.
Wait. You may proffer. Just want to make sure the jury wasn't listening.
Yes, Your Honor. Ms. Paris is just testifying that her overall goal is not to get money or become rich or to become famous, is to ensure safety as a journalist and as an investigator.
This is a tough one because I think there are merits on both sides. Relevance is a really low bar, though, so I am going to allow it, but you have a short leash.
Yes, Your Honor. Ms. Paris, I guess I'll ask again, what is your overall goal as a journalist?
Yeah, so my goal is just to make sure that everybody's safe, the environment's safe, the people that are living in the environment are safe. I just really want to provide health and safety to the well-being of this nation.
Thank you, Ms. Paris. Your Honor, I have no further questions. I just ask that my witness be able to step down.
Well, before we do that, there's no recross.
No, Your Honor.
Okay. Now the witness is excused. Plaintiff counsel, do you have another witness for your case?
Your Honor, at this time, the plaintiff rests his case.
As opposed to what other time, counselor?
Any other time that we call the witness, Your Honor? That was our last witness, and at this time we rest.
Okay. So we are at 11:25 right now. We have about an hour and 15 minutes until all loss. Because of that, we definitely are going to have to stick to 5-minute breaks because of that 702 objection earlier in the round. So we will meet back at 11:30.
Thank you, Your Honor.
Yes, Your Honor.
Your Honor, I don't believe we can hear you.
Okay, is this better? Is this better?
Yes, Your Honor.
Okay, all right. I am just going to use my headphones for the rest of the trial then. All right, do plaintiff and defense counsel, are you both ready to proceed with defense's case in chief?
Yes, we are ready to proceed, Your Honor.
The plaintiff is ready to proceed, Your Honor.
All right, defense, do you have a case to put on today?
Yes, Your Honor. We now call.
The defense calls Harper Martini to the stand.
All right, Harper Martini. Miss Martini, you've already been sworn in.
Please introduce yourself to the court.
Hi, my name is Harper Martini.
And can you tell me a little bit about yourself, Mrs. Martini?
Well, most of my life I've been in the winemaking industry. I practically grew up in Napa Valley, but I moved to Midlands for college and I traveled the world for a little after, but I ended up settling right back down in Midlands. The most important thing you need to know about me, though, is that I'm a proud mother to my son, Casey.
What can you tell us about your son, Casey?
He's just my pride and joy. We've always had a pretty close relationship, and he actually even started to kind of help me with my winemaking business as he got older. He's the reason why Peony Estates, which is the winery that I opened in 2015, is also a bed and breakfast. Casey's only flaw was Genesis.
I'd like to talk about what you mentioned last. Can you elaborate on that?
Well, I found out that Casey and Genesis began dating in 2016. And when I found out, I honestly wasn't that happy. I wasn't a huge fan of Genesis because I felt that she was a bad influence on Casey. You should have seen some of the predicaments that she got him into. And she also wasn't very good for business.
What were some of those predicaments that Genesis got Casey into?
There were plenty of instances, but the one that scared me the most was when Casey ended up in the hospital with alcohol poisoning because of some bet that Genesis had made him.
And how was Genesis have a negative impact on your business?
Casey would bring her around pretty frequently to Peony Estates, and she never really had anything nice to say, which is something in and of itself, but she also would bad talk our service and our quality to guests. I had hoped that Casey would see that Genesis just wasn't a great influence, but I was proven wrong in 2018.
What happened in 2018, Mrs. Martini?
Casey and Genesis got engaged. I tried talking to Casey a little bit afterwards about making such a big life decision, but Casey made it really clear that Genesis was the one for him.
And how did you respond to that?
All I've ever wanted as a mother is to see Casey be happy, and it was obvious that Genesis was a huge part of that for him. I might not have been the biggest fan of Genesis, but if she was going to be joining our family, I wanted to try and set our differences aside and give her an olive branch.
How did you try to make these amends with Mrs. Petrillo?
Well, I actually hosted Genesis and Casey's engagement party back in June 2018. And during that party, I tried to make some lunch plans with Genesis so that we could smooth things over.
Were you able to have lunch with Genesis?
Yeah, we ended up getting lunch together in January of 2019. And honestly, I was pretty excited. I knew that Casey was so excited to finally marry her, and I really wanted to have a good relationship with his wife. And I figured that this would be my perfect opportunity. It didn't go quite as planned, though.
Well, why didn't it go as planned, Mrs. Martini?
Towards the end of our lunch, Genesis mentioned something about a move. And then a few months later, I found out that apparently her and Casey were considering moving to France after their wedding. I felt really blindsided that my son might be moving across the world and hadn't said anything to me.
Did you do anything after learning about this?
Yeah, I tried calling Genesis the next day just to figure out what was going on. I tried convincing her that moving across the world was a terrible idea because Casey had his entire life set up right here in Midlands. but Genesis just wasn't being very receptive to it. I let it go for that conversation, but I'm not proud of it. But I did try to make a last-ditch effort to see if I could stop the wedding.
How did you try to stop the wedding?
Like I said, I'm not proud of it, but I wrote Genesis a note in May of 2019 and offered her some money.
Would you recognize a copy of that note if I were to show it to you in court today?
I would.
Your Honor, permission for co-counsel to display Exhibit 24 on the screen?
Sure. Yes, that's fine. We're going to assume that the jury cannot see this.
Yes, Your Honor. Ms. Martini, do you recognize this document?
I do, yes.
Is this a true and accurate copy of the note you wrote for Genesis?
It is.
And have any changes been made since you wrote this note?
No, not that I can tell.
Your Honor, I now offer what has been marked for identification as Exhibit 24 into evidence.
Any objections?
No, Your Honor, no objections at this time.
As opposed to what other time?
Any other time that I would make an objection, Your Honor.
Okay. The exhibit will come in as Exhibit 24.
Ms. Martini, why did you write this note?
I wrote Genesis the note because I thought that she was leading Casey down the wrong path. I offered her some money, $300,000, because I hoped that that would be enough to convince Genesis that she could still move to France and have a nice little start there, but I wanted her to call off the wedding so that Casey could stay here.
Your Honor, permission for co-counsel to take down Exhibit 24?
Yes, ma'am.
Did Mrs. Petrillo respond to your offer?
Yes, about a month later, on the day of the rehearsal dinner, which was June 7th, 2019, she actually gave me back the note that I'd written. And while that wasn't ideal, I understood that Genesis would officially be joining my family. And I wanted Casey to have the perfect wedding. So I hoped that putting together a little last-minute peace plan would really help start us off on the right foot as a family.
And what was this peace plan?
I wanted to give Genesis a bottle of Peony Estates' newest wine called Cara, and I really thought it would be the perfect gift for her.
Why was this Cara a perfect gift for Genesis?
Well, Casey had actually named the line, which I thought was really cute, but beyond that, I thought that it would be a good idea because the wine had a really similar flavor profile to all the wines that we'd been tasting leading up to the wedding. And I just hoped that Genesis would recognize that I'd known that she liked that flavor and I was trying to give her a gift that reflected that.
Were you able to gift Mrs. Petrillo that wine?
I was. Later that night, Casey and Genesis both gave really sweet speeches, and I went after. I just expressed how much it meant to me that my new family be happy and together, and then the caterer came and brought out that bottle and gave it to Genesis. I acknowledged that we'd had a pretty rocky relationship, but I was really excited for our future together.
And how was this gesture received, Mrs. Martini?
I thought it went over really well, which I was super excited about. Casey seemed really appreciative, and honestly, that was all that mattered to me.
Now, I'd like to move your attention to the morning of the wedding. How did that day begin for you?
Well, I woke up to this panicked call at around 2:30 in the morning or so, because apparently someone at Peony Estates was being rushed to the hospital. The night before, I'd seen Genesis drinking a decent amount, so I decided to go to her room just to make sure that everything was okay.
What happened when you got there?
Genesis was nowhere to be found, but I did find that bottle of Cara that I'd given her the night before, and it was completely empty on her floor. I just couldn't believe that this was happening on the day of Casey and Genesis's wedding, and I really wasn't sure what to do.
So what did you decide to do next?
I was frustrated. I tidied the room because I didn't want Casey to come in and see what I thought was some drunken mess that Genesis had left around the room. I figured that Genesis would be back in time for the wedding since it was 2:30 in the morning, so I just went back to sleep.
Did Mrs. Petrillo turn up in time for the wedding?
No. At around 9, we found out that Genesis had slipped into a coma. Casey rushed to the hospital to be with her, but I stayed behind because wedding guests were coming in and I had to talk to them and let them know what was going on. A couple of hours later, I found out that Genesis had passed away.
Mrs. Martini, What is your response to the allegations that you are responsible for Mrs. Petrio's death?
I'm very open about the fact that Genesis and I didn't have an ideal relationship. To the extent that I was worried about her leading Casey down the wrong path, I'm glad that I don't need to worry about my son anymore. But I also care about Casey more than anything in this world. And I know that Genesis was that same thing for him. The allegations I would do something like this is ridiculous, especially because it involves my family.
No further questions, Your Honor.
All right, thank you very much, Attorney Solis. Attorney Kim, your witness.
Thank you, Your Honor. Ms. Martini, I just have a couple questions. If I understand that this is a pretty hard time, so if you need to take any time at all, please take your time.
Thank you.
Your Honor, at this time, I'd like to share my screen and pull up Exhibit 24, which the defendant has put into evidence.
Go right ahead.
Ms. Martini, this is Exhibit 24. This is the note that you wrote to Genesis, correct?
It is, yes.
All right. And could you follow along silently as I read out loud?
Sure.
Genesis, it has come to this. The wedding can't happen. I need you out of our lives. Leave Casey, and the enclosed $300,000 is yours. Otherwise, I will take you out of the picture the hard way.
Objection, Your Honor, cumulative.
Is there a technical issue going on?
Your Honor, I believe the opposing counsel objected to cumulative.
Oh, okay. I'm sorry. I think my internet might have just gone out for a second.
Your Honor, yes, I did.
And how much of the letter did you read, counsel?
I read up to otherwise I will take you out the hard way.
Yeah, I'm going to sustain the objection.
Your Honor, I ask that that testimony be stricken from the record.
So stricken.
So, Your Honor, is just the sentence, that specific sentence, taken out of the record?
The entire question that you asked will be stricken from the record.
Does that mean the entire exhibit is stricken from the record? I was just reading from the exhibit.
The exhibit is still in evidence.
Okay. Am I allowed to? Sorry.
Yeah, if you want to read specific excerpts of the exhibit, that's fine. But to do an amount of reading that would, the jury's already going to be able to have the opportunity to read this when they go to deliberate. So it is cumulative to read a majority or entirety of an exhibit.
All right. In that case, I will stop sharing and continue my line of questioning. Ms. Harper, you presented the car wine to Genesis, correct?
Yes, I wanted to give it to her, but the caterer is the one who actually ended up presenting it to her that night.
And did you personally bottle the car wine?
I did, yes.
And it was bottled in the bottling room, correct?
It was, yes. That's where all our wine is bottled.
That's the same room that was housing the pesticides, correct?
No, that's not true.
Okay. You saw Genesis drink from the car wine, correct? He drank it?
Yeah, I think I saw her pour a glass.
Sorry. And did you see anyone else drink from the car wine?
I don't think so, but I turned in pretty early that night.
Miss Harbert, you mentioned in your testimony that you knew someone was at the hospital at 2:30 in the morning.
Yeah, I'd gotten a phone call from one of the Peony Estates employees.
And you knew that they were one of your employees, correct?
I did, yes.
Was Genesis the first person you thought of that went to the hospital?
Yeah, like I said, I'd seen her drinking quite a bit before, and she's gotten Casey into some sticky situations with alcohol as well, so I figured I'd just go check on her.
And when you didn't see Genesis in their room, you didn't think to go to the hospital or check if everything was okay?
Well, no, I wasn't quite sure what to do, and I assumed since it was around 2:30 in the morning that she would come back in time for the wedding the next morning.
All right, thank you. No further questions.
All right, thank you very much, plaintiff counsel. Defense, any redirect?
No, Your Honor, I ask that this witness be excused from the witness
All
stand.
right, Ms. Martini, thank you very much for your time today. You can step down. All right, defense, do you have any more evidence for your case in chief today?
Yes, Your Honor. The defense calls Dr. Cannon to the stand.
All right, Dr. Can, you have been sworn in. Please take the stand. Proceed when ready.
Dr. Cannon, I can't see your video. A moment, Your Honor. I'll try to see if there are any technical issues with Dr. Cannon's video.
No problem. Take your time.
We are having an issue with internet connection. I don't think it'll take more than a minute, though.
All right, thank you for letting me know.
Your Honor, it seems that the issues still persist. Do we have permission to call Blair instead? Then we'll call Dr. Cannon afterwards.
Sorry, I was muted. That is completely fine. We will presume that the order in which the witnesses are being heard constructively will remain the order that you wish, despite the technical issue. I guess Blair Osborne is the witness that is going to be called, correct?
Yes, Your Honor.
All right. All right. Blair Osborne, you have been sworn in. I will let the defense counsel begin with questioning whenever they're ready.
Thank you, Your Honor. Good morning. Please introduce yourself.
Sure, I'm Blair Osborne.
What do you do for a living?
I am the CEO and owner of Bliss by Blair Events. I arrange conferences, birthday parties, corporate retreats, but I'm mainly known for my wedding planning.
How long have you been involved in the event industry?
Since 2015. Actually, when I first began, I accidentally double booked a wedding reception and really needed a new venue. Thankfully, Peony Estates came to my rescue.
How did Peony Estates help you?
I called last minute and this very nice lady called Harper Martini answered, and she was gracious enough to let us use Peony Estates as a last minute venue. Ever since then, we've had a great partnership.
What is your relationship with Ms. Martini like?
We would often host our events at Peony Estates. So my company would plan the events and Peony Estates would host them. It was a great partnership. And after years at working at Harper's Winery, her employees and I developed a deep but strong bond. In fact, I even ended up planning Harper's son's wedding to Genesis.
I actually want to talk about that wedding. Who hired you as the planner?
It was Harper Martini. And of course, I was ecstatic to plan their wedding. They're like family to me.
How was that experience planning the wedding?
It could be tense. Weddings are often stressful, and Genesis and Harper did bicker a lot, but that's what in-laws do. They bicker.
You said things were tense between Genesis and Harper. What do you mean by that?
Yes, so they disagreed over the catering, flower arrangements, decorations, the whole shebang. But it's normal to see these type of things. In fact, I've seen so many wedding arguments. 2 years ago, this bride wanted a red velvet cake, and her mother-in-law disagreed, to say the least. And she grabbed a baseball bat and smashed the wedding cake. So I would say that bickering is pretty normal in the wedding industry. In fact, Harper tried to extend an olive branch to Genesis to smooth things out. She seemed eager to make amends.
You mentioned that Harper wanted to make amends. When did this happen? What was going on there?
So in the night of the rehearsal dinner, she offered a gift to Genesis, and it was so lovely. I'm not normally much of a crier, but I'll admit it made me tear up a bit
Why were you so moved?
because I knew that Harper was going to give people gifts, but I wasn't expecting her gift to Genesis to be so genuine and full of love.
Why weren't you expecting it to be so genuine and lovely?
On a serious note, they did bicker a lot, so it was special to see Harper genuinely wanting to change her relationship with Genesis.
Objection, speculation.
All right, defense response.
We're not speculating here. The witness is simply speaking about what they saw based on their rational perception.
Okay, response plaintiff.
Yes, Your Honor. The witness cannot know the exact mindset of Harper Martini, cannot know that she truly wanted to make a peace offering, that she wanted to extend an olive branch.
May I respond, Your Honor?
Sure.
The witness was present when all these events were occurring and is simply speaking to the behavior of Harper Martini. Extending an olive branch is a reasonable conclusion to make based on Harper Martini's actions.
Yeah, I think it's a sound objection, but I'm going to overrule it. I think especially with the presence of a gift, and that certainly seems like extending an olive branch. Yeah, I'm going to overrule, but it was close.
Mr. Osborne, what was this gift?
It was a beautiful bottle of wine.
And how did the rest of the rehearsal dinner go?
After the speeches, I saw Genesis with a few members of the wedding party. They looked like they had a bit to drink, and it's typical to see people enjoying themselves on the day of the wedding. And Harper, knowing that Harper and Genesis were made amends, made me super excited for the next day. Unfortunately, it didn't go as planned.
What happened the next day?
On the day of the wedding, we learned that Genesis has slipped into a coma. We later found out that he passed away. I was completely shocked and horrified. Right when Harper and Genesis were inching towards a beautiful in-law relationship, everything fell apart. It was even worse after hearing the allegations.
What allegations?
Some people were alleging that Harper had something to do with it, but Harper was repairing her relationship with Genesis. She was doing that for Harper. Harper loved Casey far too much to ever do anything like this.
Speculation to the statement that he was doing it for Harper.
Yes, Your Honor.
Okay, response, defense.
I believe the witness meant to say that they were doing it for Casey.
If I may be heard, Your Honor.
Sure.
Even if the witness meant to say something else, what the witness said is what has been said, and the witness can testify to his own rationally based perception of the event. He cannot testify, however, to anyone else's mindset at the time of the event.
Okay. Do you still object if it was meant to be for Casey, not for Harper?
I do.
Okay, defense on those grounds.
I believe that because the witness was around Casey and Harper, considering they were the wedding planner, it's within their rationally based perception to understand Harper's goal was to do this for their child.
Okay, I am going to first provide the jury with a corrective statement, which will instruct them that the statement is meant to be for Casey, not for Harper. And then yeah, this is a tough one. I'm going to overrule.
And we're returning to the question. What, go ahead and finish your statement, Mr. Osborne.
Yeah, so some people were alleging that Harper had something to do with it, but Harper was repairing her relationship with Genesis. She was doing this for her son. Harper loved Casey far too much to hurt him like this.
Thank you. No further questions, Your Honor.
All right, Attorney Sager, it's your witness.
Yes. Mr. Osborne, I just have a few questions for you. You found planning the wedding of Casey Soto and Genesis Petrillo to be particularly difficult. Is that correct?
It was tense, yes.
In fact, you noticed that this was the worst professional experience of your life. Is that correct?
Yeah, that's why you can't mix family and business.
All right. And you sensed tension between Miss Martini and Genesis. Is that correct?
Yes, they did bigger.
You found that crying and fighting were in fact the theme of planning this wedding. Is that correct?
Yeah, most themes are like that.
But particularly for this wedding, being the worst professional experience of your life, crying and fighting were the theme of this wedding in particular. Is that correct?
Yes.
And you also sensed tension between Miss Martini and Casey. Is that correct?
Yes.
Okay. Harper and Genesis were insulting each other at the party the night before the wedding. Is that correct?
Yeah, they do bicker a lot, as in-laws always do.
And you heard Harper say that one day Genesis would drink the wrong thing and it would kill her, correct?
Yes, I did.
Okay. And Miss Martini told Genesis that the bottle of wine was only for her and that no one else was to drink it. Is that correct?
It was a special gift for the person who was getting married, so yeah.
Miss Martini told Genesis that she was to drink the bottle of wine only when no one else was around. Is that correct?
She told that in front of everyone, yes.
All right. And when Harper found out Genesis had died, she didn't react, correct?
Well, people grieve differently, so I guess you're right, but I don't know if she was grieving or not. I'm not a psychiatrist.
All right. No further questions, Your Honor.
Any redirect?
Apologies. No, Your Honor.
All right, Mr. Osborne, thank you so much for your time. You are excused. Defense, do you have any more evidence for today's case?
Yes, Your Honor. The defense calls Dr. Cannon to the stand.
Wonderful. Dr. Cannon, glad to see you. Thank you so much for appearing today. You have already been sworn in. Constructively, this is going to be the second witness that the jury is hearing from, and the defense can proceed when ready.
Yes, Your Honor. Good morning. Could you please introduce yourself for the court?
My name is Dr. Rhiannon Cannon.
And what do you do for a living, Dr. Cannon?
I am a medical doctor, although apparently I can't figure out how to fix my PC other than rebooting it. I have practiced in the medical field and have served as a professor of toxicology. For the past 6 years, I've served as a partner in Gardner Consulting, Inc., which is a medical consulting firm based in Southern California. Previously, I've served as a professor of toxicology at Midlands Medical School, and prior to that, I was the director of toxicology at Mass General. I'm also board certified in toxicology.
And what educational background do you have to hold your position?
Well, I have an MD from Harvard with an emphasis in toxicology. I graduated with honors with a Bachelor of Science in Chemistry from The Ohio State University.
Have you ever been published in your field?
Oh yes, many times. I've authored more than 50 publications specifically related to toxicology, medicine, and relevant treatment.
And why are you here today, Dr. Cannon?
Well, I was hired by counsel for Harper Martini to review and comment on the facts in the case related to the death of Genesis Petrillo and the conclusions of Dr. Kwan.
Well, what materials did you have in conducting your work on this case?
I reviewed all the records pertinent to Petrillo's death, specifically the toxicology reports, the death certificate, the chemical analysis, the alcohol impairment chart. I also reviewed certain affidavits.
And were these materials sufficient for you to come to your conclusions?
Indeed, from a scientific and medical perspective, they absolutely were.
And what method did you use in today's case?
Well, outside of my own vast medical expertise, I used what is called the METH method. And this stands, it's an acronym for the molecular evaluation to holoenzyme.
And is this method standard practice in your field?
Indeed it is.
And could you explain this METH method more for the jury?
Indeed. Put simply, it evaluates the molecular level of any given toxin as it relates to the native conformation of a functional holoenzyme, thus determining the degree of toxicity. This is universal, reliable, and well respected for a secondary toxicology analysis.
And how did you apply the METH method in today's case?
Well, I analyzed the data as it related to the blood alcohol level of the deceased, as well as the presence of organophosphate in the decedent's body, particularly isofenfos, a common pesticide.
Well, let's start with your analysis of the data for alcohol. What did you find?
The decedent's blood alcohol was measured in the hospital at 0.16%, which is extremely unlikely to cause death. Because this would be highly unlikely, I also considered additional facts that were not reflected in Dr. Kwan's report, which led me to a more accurate conclusion.
What facts are those, Dr. Cannon?
Well, the deceased was apparently a person who drank often, and heavy drinkers metabolize alcohol faster. This is a biological fact. In addition, Petrillo's blood alcohol was 0.16 at 3 a.m., according to Dr. Kwan's report, yet apparently Petrillo had been drinking from much earlier that evening. And this is an important distinction because it means that blood alcohol was reduced over the course of the evening.
And how did these facts regarding her blood alcohol content reflect in your conclusions compared to those of Dr. Kwan?
Well, at the time the paramedics were called, Petrillo's blood alcohol was most certainly higher, possibly in the lethal range. Yet Dr. Kwan did not address how Petrillo's blood alcohol level had to have been higher mere hours before the test was actually conducted. So alcohol poisoning is a very real possibility.
Now, I'd like to direct your attention to the second toxin you reviewed analyses on, isofenfos. Could you tell the jury more about your findings on that?
Indeed. This is where the METH method is most accurate. I compared the level of pesticide found in Petrillo's stomach to the acetylcholinesterase and acetylcholine levels, which are inhibited by alcohol. Again, I found that there were some crucial medical findings that Dr. Kwan seemed to naively ignore. He has a reputation.
And what details are those, Dr. Cannon?
Specifically, the elevated high levels of isofenfos and acetylcholine, the stomach contents, and the range of presented symptoms. This important data was not apparently considered.
Well, how did this important data affect your conclusion compared to that of Dr. Kwan?
Well, when taken together, the pesticide and acetylcholine levels can be correlated, but they cannot with any scientific certainty be determined to be the only cause of death, as Dr. Kwan stated in his report. There are a number of other possible causes, but Dr. Kwan seemed to have picked the easiest answer and just ran with it.
Now, you mentioned that there were other possible causes for Ms. Petrillo's death. Could you explain to the court what those causes are?
Indeed. The bottom line is that there are numerous plausible explanations for Petrillo's death. To name a few, hepatic disease, an allergy to other food or drink, or actually other food and drink that was consumed that evening, and so on. None of these possibilities can scientifically and medically be excluded.
And Dr. Cannon, if someone were to drink a contaminated wine with pesticides and then spit it back out without swallowing, what, if any, symptoms would there be?
Well, if the toxicity level was high enough to cause lethality when ingested, if it had been absorbed through the skin, it would have at minimum caused a bitter taste, a rash, blisters in the mouth, a potential bleeding of the gums, and so on.
Finally, you mentioned that earlier that your knowledge of medical practice also came into effect in making your conclusion. Could you explain exactly how that is?
Well, I've had many, many years of experience with patients that have suffered from toxic substances, as well as alcohol being introduced into the body simultaneously. And I was rather surprised to read that a respirator had not been used in Petrio's care.
And why does the fact that Dr. Kwan didn't use a respirator concern you?
Well, a respirator would have been indicated, considering that was the primary cause of death in the certificate. But specifically, alcohol and isofenfos are each substances which inhibit normal breathing. Either way, labored breathing means a respirator, period. I find that Dr. Kwan failed to take that potentially life-saving measure.
Well, based on everything you reviewed, in your expert opinion, what would you label as Ms. Petrio's cause of death?
Well, considering Dr. Kwan's premature, shaky conclusions and the existence of many other plausible conditions that could have caused the death of Petrio, my answer is, sadly, there is really no answer. It's a shame that a young person like Petrio passed away, but it would be adding insult to injury to attribute an incorrect cause of death just for the sake of closure.
Thank you, Your Honor. No further questions.
All right, thank you for that. Plaintiff counsel, your witness.
Thank you, Your Honor. Good morning, Dr. Cannon. I just have a few questions for you. Dr. Cannon, you have a particularly large client that you could lose if you testified that pesticides killed Genesis Petrio, correct?
Oh, you mean that blowhard death fee? Yes, that's correct.
And you were unable to personally examine the body of Ms. Petrio, is that correct?
Secondary medical analysis after death does not usually even include the body, but yes, you are correct.
When drawing your conclusions, you found that it was highly unlikely that those four potential causes of death that you listed were the actual cause of death, correct?
Well, everything is likely. It makes no difference whether it's highly unlikely or less likely. The decedent is indeed dead.
Is that a yes to my question that you found that the other possible causes of death were in fact highly unlikely?
No, not highly unlikely. They have varying degrees of likelihood.
Is it your sworn testimony today that you did not find that your other causes of death were potentially highly unlikely?
Oh, indeed. Other causes of death were highly unlikely. Indeed, yes.
So the causes of death that you explained in your direct examination were in fact highly unlikely. Is that correct?
With varying degrees of likelihood, indeed you are correct.
You have never seen a blood alcohol concentration of 0.16, that of Ms. Petrio, kill someone before. Is that correct?
That is correct.
You concluded that it was highly unlikely that she could have died of alcohol poisoning, correct?
Unlikely, but not impossible. Indeed, you are correct.
You investigated an allergic reaction as the cause of her death, correct?
I did.
You also concluded that it was highly unlikely that an allergic reaction was the cause of death, correct?
Unlikely, but possible. Yes, you are correct.
Thank you. You concluded that it was the least likely that Ms. Petrio could have died of hepatic disease because she lacked that crucial symptom of jaundice. Is that correct?
That is correct, yes, but still possible.
And you discovered that the inside of the bottle of wine tested positive for organophosphate pesticides, correct?
That is what happened, yes, indeed.
You discovered that none of the buffet food that was eaten by Miss Genesis Petrio or other members of the wedding party tested positive for organophosphate poisoning, correct?
As far as the information provided to me, indeed, you are correct.
And when you looked at the analysis of the contents of Miss Petrio's stomach, it showed that wine was the only contents and none of the food of the buffet was in her stomach, correct?
I believe that there were multiple contents in the stomach over the course of the evening, and whether or not they were present at the time of the autopsy or the time of the report. The fact is that the chemicals and nutritional contents, whatever, are immediately begin the absorption process through the stomach, then they go through the duodenum, and then they enter the small intestine. And it's pretty quickly, especially exacerbated by alcohol.
So to clarify the answer to my question, that in the analysis of Miss Petrio's stomach, wine was the only content that was discovered, correct?
I believe that is correct, yes.
No further questions, Your Honor.
All right, any redirect for Dr. Cannon?
No redirect, Your Honor. I ask that this witness be able to step down from the stand.
All right, Dr. Cannon, thank you so much for your time today. You are excused.
Thank you.
Defense, do you have any other witnesses to call for your case?
No, Your Honor. The defense now rests and asks that we have a brief 5-minute recess if time permitting.
All right, how much time do we have for each closing? Because I know it's 12 minutes total per side for statements, so I don't know how much time is remaining per side for closings.
Yes, sir. For the plaintiff, closer has 9 minutes and 43 seconds remaining.
Yep.
And defense closer has 7 minutes and 46 seconds.
Your Honor, I do believe
Yeah.
lost time is 12:40.
Yeah, I think we should just take 3 minutes, to be honest. So we'll get back at 12:16. All right. Can we hear, or can you hear me at this point?
Yes, Your Honor.
All right, just turned 12:16, and we are really pushing the all loss. So let's try and get skippy with it. My fellow judge and I are both on track for once the closings are done, we're ready to submit our ballots. So we just need to put in closings and attorney ranks. So plaintiff can proceed when they're closing, whenever they're ready.
I apologize, Your Honor.
No problem, you can proceed.
Thank you. Your Honors, opposing counsel, members of the jury, and may it please the court. My name is Lauren Sager, and today I rise to represent the plaintiff, Joey Petrillo, as administrator of the estate of Genesis Petrillo, along with my co-counsels, Julia Robertson and Colin Kim. Your Honors, actions have consequences. Two sides of this story were presented today. One of a hateful offense by a mother who could not forgive and forget, and one of, quite honestly, something else that wasn't conclusive. The truth of the matter here is that Harper Martini intentionally poisoned the wine that she gave to Genesis Petrillo, and that Ms. Petrillo drank the wine and died, just as Martini had intended. Actions have consequences. The plaintiff bears the burden of proving by a preponderance of the evidence that Harper Martini acted with intent to cause harmful or offensive contact to Ms. Genesis Petrillo, and that as a direct and proximate result of the foregoing, the plaintiff has suffered harm. Your Honors, the Supreme Court of Midland stated in the case of Sridhar v. Gandham that a battery is an intentional tort and that non-consensual touching is all that is required. Additionally, the elements of civil battery, according to the case of Burdett v. Copenhaver, are 1, an act by a defendant, 2, an intent to cause harmful or offensive contact on the part of the defendant, and 3, actual harmful or offensive contact to the plaintiff. And pursuant to the case of Jacob v. Alexander, the touching that is necessary for a battery to occur does not require that the defendant's physical person make contact with the plaintiff's physical person. Therefore, Your Honors, Harper Martini's act to introduce an injurious substance into Genesis Petrillo's wine does indeed constitute an offensive touch under the precedential definition of a battery. Martini intentionally mixed pesticides into the Cara wine. And finally, from the case of Nugent v. Peel, direct causation means but for the defendant's actions, the plaintiff's harm would not have occurred. And proximate causation means that the plaintiff's harm was a reasonably foreseeable result of the defendant's action. Actions have consequences. Martini acted with intent to cause harmful or offensive contact to Ms. Genesis Petrillo. The plaintiff called 3 witnesses today. First, you heard from Angel Rodriguez, who testified to the fact that Harper specifically targeted Genesis, that her attitude as well as her actions toward her were demonstrative of this disdain for Genesis Petrillo and her relationship with Casey Soto. Next, we called our expert witness, Dr. Jameen Kwan, a toxicology specialist, to testify to the fact that Genesis Petrillo died of respiratory failure due to organophosphate poisoning, and that Petrillo's symptoms followed the exact progression of a typical case of organophosphate poisoning. Thirdly, you heard from Lonnie Paris, who testified to the rocky relationship between Harper Martini and Genesis Petrillo, and her investigations around the property further proves the fact that Harper Martini was specifically targeting Genesis Petrillo. The opposing counsel's case, the defense's case, called 3 witnesses, yet none were able to admonish Harper Martini of the guilt that is present. First, they called Harper Martini herself. But Harper was playing a character. Harper was telling a story which does not reflect the reality of the situation. Harper can get on the stand and tell you all day that she loves her son and that she loved Genesis, but her actions, as testified to by prior witnesses, Angel and Lonnie specifically, speak louder than her contradictory and false words. Next, the defense called Blair. Mr. Blair Osborne testified to the fact that this wedding was indeed the worst professional experience of his life, that it was marked by tension, specifically fighting between Ms. Genesis Petrillo and Ms. Harper Martini. And finally, they called Dr. Cannon, their expert witness, who concluded that all other possible causes of death, other than the organophosphate poisoning, were indeed highly unlikely. While Dr. Cannon also stated that organophosphate poisoning was highly unlikely, you previously heard from Dr. Kwan, who contradicted that statement, and we ask, as the plaintiff today, that you consider Dr. Kwan's more reliable testimony over Dr. Cannon's testimony for the following reasons. First, Dr. Cannon made an argument about blood alcohol concentration, which doesn't reflect the reality of blood alcohol concentration. Dr. Cannon stated that even though Ms. Petrillo's measured blood alcohol concentration at 3 a.m. was 0.16%, it could have been higher earlier. Therefore, poisoning could have led to her death. However, it's immaterial how quickly Ms. Petrillo may metabolize alcohol, and it's immaterial what the potential alcohol content level was earlier in the day. What matters most is what Ms. Petrillo's blood alcohol concentration was closest to the time of her death. And because it was 0.16% at 3 a.m., and if Dr. Cannon is correct in assuming that Ms. Petrillo metabolizes alcohol quickly, then her blood alcohol concentration would have been much lower at the time of her actual death later that morning. Therefore, alcohol poisoning, as Dr. Cannon herself admitted, is highly unlikely to have been the cause of Ms. Petrillo's death. And once again, the plaintiff asks that you consider Ms. Kwan's testimony over Dr. Cannon's testimony, as it is much more reliable and conclusive of the reality of the situation that Ms. Petrillo died, in fact, due to organophosphate poisoning that was the direct and proximate result of Ms. Martini's actions against her, intent on causing the plaintiff to suffer harm. We ask the jury today to find Harper Martini liable for the death of Genesis Petrillo as a result of battery by Harper Martini. Actions have consequences. Thank you.
Thank you very much, counsel. Defense, you can proceed when ready. If plaintiff counsel can turn off their video.
Yes, Your Honor. Your Honor, opposing counsel and members of the jury, may it please the court. Just because an answer is convenient doesn't mean it's right. Today, we have seen the plaintiff take the convenient road to their conclusion, not being concerned about harming a grieving family or being concerned with what is right. Throughout today's trial, it has been clear to say that there were issues between Mrs. Martini and Miss Genesis Petrillo. However, it has been even clearer to see that Mrs. Martini's love for Casey, her son, shone throughout everything that she did in her life. Did this love cause concern for Casey? Yes. Did it cause issues between Casey and Genesis and Harper? Yes. But ultimately, it led Mrs. Martini to seek peace with Genesis for the sake of her son, Casey. Because Mrs. Martini was aware that Genesis was a vital part of Casey's happiness and that the wedding would occur with or without her support, she decided to extend that olive branch to Genesis Petrillo, to welcome her into her family with open arms as part of her peace plan. And today, we have seen the plaintiff turn that peace plan inside out and upside down, missing entire parts of the story, and was Mrs. Martini worked to mend things with Genesis Petrillo, simply for the convenience of their own story. Now, as my co-counselor, Mrs. Kanduri, explained in opening statements, the burden of proof does not rest on the defense in today's case. It rests solely on the plaintiff, and they had to prove by a preponderance of the evidence Mrs. Martini liable of battery. Now, that charge comes with three major elements. The first being an act by the defendant, the second being intent to cause harm, to the plaintiff on the part of the defendant and harmful or offensive contact to the plaintiff. So by law, they had to come today and prove that Mrs. Martini intended to harm Genesis Petrillo, and that what harmed Genesis Petrillo was the wine gifted on the night of the rehearsal dinner. However, throughout today's trial, it has been clear that that burden is too much for the plaintiff to bear. So first, they had to prove that Mrs. Martini had the intent to harm Genesis Petrillo. However, members of the jury, all you've seen throughout today's trial is a mother who was concerned for her son, a mother who loved her son. The plaintiff has twisted this concern and this love into a hatred for Genesis Petrillo, which is simply a misrepresentation of the facts. As Blair Osborne explained, as an experienced wedding planner who is around these types of events quite often, it's clear to see that in-laws fight. They have disagreements. And Mrs. Martini was honest and forthcoming about the fact that she didn't want Mrs. Petrillo to marry her son Casey, and she had valid reason for that. However, that does not prove intent to harm. Not one witness took the stand today and said that Mrs. Petrillo had ever harmed, that Mrs. Martini had ever harmed Genesis Petrillo. In fact, the plaintiff promised you in opening statements that you would hear of this physical harm, but you never did. You never heard one instance in which Mrs. Martini harmed Genesis Petrillo. You only heard of a concerned mother worried about the happiness and safety of her son. In fact, what you did hear was about a peace plan, about multiple attempts for Mrs. Martini to build bridges and to make amends. She planned many events to celebrate the happy couple, went to lunch with Genesis Petrillo to extend an olive branch to her, crafted a peace plan in which she was the sole character in that. She wanted to ensure that Genesis felt like an open member of her family. And finally, she acted out that peace plan. She gifted Genesis Petrillo a gift that was meant to mend, not to harm. And many witnesses took the stand today and were able to testify that. However, the plaintiff offered you two witnesses that had never experienced anything in regards to Mrs. Martini and Genesis Petrillo's relationship. Lonnie Peros was not around during the wedding planning processes, and neither was Angel Rodriguez. Neither of these witnesses can testify to it, but you heard it testified to on the side of the defense by Blair Osborne and by Mrs. Martini herself. This was love, and it was concern. It was not intent to harm. Now, secondly, the plaintiff had to prove that what actually killed and harmed Genesis Petrillo was the wine gifted from Mrs. Martini. But members of the jury, there are simply too many questions in regards to that. First, during the cross-examination of Angel Rodriguez, it was clear to see that Mrs. Genesis Petrillo drank a lot the night of the rehearsal dinner. In fact, Mr. Rodriguez allowed Mrs. Petrillo to continue drinking for many hours after she was already too incapacitated to be able to talk correctly or walk across the stage correctly. Mr. Rodriguez had to drag Genesis up the stairs because she was so intoxicated. And even after that, he allowed her to be alone for multiple hours, which could have caused the harm that Mrs. Cannon talks about in her direct. Furthermore, when we look into the cross-examination of Dr. Kwan, we see that the way in which this conclusion was come to is just too questionable to blame Mrs. Martini for this death. We can't even test for the presence of organophosphate in the blood or in the body. We simply have to make a conclusion on the acetylcholinesterase levels, which, as was brought out on Dr. Cannon's direct and on Dr. Kwan's cross, is something that can be affected by many other things. These conclusions are too faulty and questionable to blame Mrs. Martini for this. And further, even if we were to prove that organophosphate was the cause of death, we can't exactly conclude that it was in the wine bottle. Mrs. Petrillo was all over the grounds of Peony Estates around the time of the wedding. There is no conclusive way to say how this happened or why it happened, simply that it is tragic. But it would only add insult to injury to blame Mrs. Martini for this simply out of convenience for the plaintiff. They made their conclusions because it fit their case, not because they were conclusive. So because the plaintiff was incapable of proving this burden today, you cannot find my client liable for battery. What was seen throughout today's trial was a love for Mrs. Martini's son. And since there was a love for Mrs. Martini's son, there was a love extended to Genesis Petrillo. It may not have been immediate, and it may not have always been seen because of spats and issues, but it was there. It was in the makings of her peace plan. It was in her decisions to accept Genesis Petrillo with this olive branch extension. It was in all the ways that she took the stand today and was honest and forthcoming about her feelings towards Genesis Petrillo. While it is disheartening to not be able to provide an exact cause of this abrupt and tragic death, the truth of the matter is that we cannot. And because the plaintiff has failed to prove that it was Mrs. Martini who is liable for this, We ask that you, the jury, find the defendant, Mrs. Martini, not liable for battery. Thank you.
All right, thank you, counsel. Do we have a rebuttal from the plaintiff?
No, Your Honor.
All right, with that, we are going to close the matter of, oh gosh, what is this case called? The estate of Petrillo versus Harper Martini and Peony Estates. Jury received their instructions, go to deliberate. If you could give my fellow judge and I a moment to finish up our ballots, we'll submit them within a couple minutes. All right, both judges have submitted their ballots. We just need to wait for, I let the tab director know that we have submitted them. He's going to let us know that he received them, and then we can go on for comments. If anyone who wants to turn on their video can do so now. No more points to be given out, so. All right. Just while I'm waiting to hear back from Elliot, the tab director, Liam, do you want to start by introducing yourself? No.
Sorry, what did you say? Were you talking to me?
Yeah. Do you want to just introduce yourself?
Oh yeah, sure. So yeah, I'm Liam. I'm currently a 1L at Duke. Did mock trial in undergrad, but yeah, some experience with it. Haven't done a lot of judging, but I'm here, and yeah, that's me. I guess Christian, if you want to do the same.
Sure. Yeah, and we just got the go ahead that our ballots are good, so we can give comments and such. All right. So my name is Christian Tulia. I was a competitor at Wake Forest University mock trial all 4 years. I was the president of our team for the last 2 years I was on the team. I am taking a year off before law school. I wasn't like Liam, who got a 180 on his LSAT. I had to study up a little bit more. And am currently working in estate planning. So really the only thing in this case that I know a lot about, besides the Midlands Rules of Evidence, is probably what would have happened with the, I guess, probate administration, and possibly with the execution of the documents themselves. But unfortunately, you aren't allowed to talk about that in this case. Yeah, I will let Liam start with comments because he's had to be quiet this whole time.
Fantastic. All right. Yeah. So first of all, I did also throw together some written comments that you should be able to get. I did make comments on, some of the technical stuff, but just, be aware, even if I commented on you having technical issues, I didn't dock any points for that. It's just more of this was an issue. Try to fix it if you can. So first of all, I guess obviously the format is a little bit weird. But I will say, especially on the plaintiff side, you guys got a lot of issues with the way you presented it. I do really appreciate you trying to stick with the format and stand up and act like it's an actual trial, but having the projector on the whole time, looking up at whatever's projected on the board, having people walking around in the background, and also especially just talking to people off screen while the other side is going, it's just not. It's not a great look. So it's not a bad idea having this sort of setup, but I would try to button that up. Again, I didn't dock any points for that. That's more of just going forward, the less distractions, the better, essentially. As far as overall content, again, I'll stick to mostly what I had in the written stuff, but just overall, especially something I think is important is being prepared for objections more generally, both in the ones that you're going to be making and in the ones you're getting. As a lot of these are ones that you could predict pretty easily that are either going to get objected to. So you should have a response ready. Your response should be clear, and you should just be right, bang, bang, bang. This is why, this is the rule, and this is why I'm right. And, be a little bit more confident about that. I thought on both sides, there were some instances where on stuff that you probably should have seen coming as an objection, you weren't as confident in making an argument or in supporting that as perhaps you should be. I mean, I know it's early in the process, but just something to keep in mind. And then the other issue is notes. It's obviously, again, early in the process, but it is super obvious when you're reading. When you have someone looking off to the side after every single question, when you have someone whose eyes are just going like this the whole time, and that's very distracting. And especially on the witness side, that's not something that you'd have the advantage of doing if we were in an actual invitational here. So I think in particular in witnesses, I mean, there's usually some excuses for attorneys at this point. You have your notes, you have maybe some bullet points, but I think the witnesses especially need to be more confident in the material and have a better grasp on that more generally. That's basically what I got. Like I said, if you have any individual questions and we have time, maybe we can bump into some of those, but everything else is in the written questions.
I would definitely echo what Liam said. Definitely no points were docked for tech issues. Definitely glad we were able to hear from you, Dr. Cannon. I thought your testimony was wonderful. I mostly did experts when I was doing mock trial. Liam and I, we actually know each other from doing mock trial together in high school. We went to high school together in Massachusetts. Way back, and we did mock trial then. Yeah, I think that for technical issues, I would agree with that. I would suggest to the plaintiff side, I think it's more effective to be in different rooms and have each person have their own device. I know it's more complicated, and you might not have that ability. And if you don't, then ignore it. No judge should ever dock points for something like that, given the circumstances that we're in. But that would just be my suggestion, because part of it is, I am a type of judge who likes to address people by name. And sometimes I think I call one of the attorneys, Attorney Kim, when really that was not who I was speaking to. And so, you don't have to worry about changing the names and stuff like that. All right, going on to the trial itself. I thought the witnesses all did a really good job. The statement that I usually make is that witnesses make or break the trial. They are the ones who are going to determine usually if you win or lose the ballot. It's very true. And I think that the witnesses in this case were all, very believable. They had good character. I think just a general suggestion is to speak with more inflection. Use more hills and valleys is what I was always taught. And, make it as interesting as possible. I thought Harper Martini, you did a very good job with that. So props there. Let's talk about the experts. I was so happy when we got the 702 objection. So part of it is that there's no 702 is the objection to make when it's an improper conclusion, expert conclusion, but that's not actually what the objection is. The objection is lack of foundation, essentially saying that the expert does not have the foundation needed to be able to make a conclusion. And what I was trying, your objection was quite honestly near perfect. The only thing that I was trying to get out of you more was to cite case law, particularly if you had used Terror Readers Associations of Midlands versus Merrill Dow. I would have sustained the objection right there, because the opposing counsel did not name a single one of those elements. So even though that list is not dispositive and it's up to the judge to decide, I'm in the belief that if you don't list a single one of those reasons for why a method is reliable, then that is enough for me to sustain the 702 objection. I thought, plaintiff, I forget who was fighting that objection, but you did a good job. You're very adaptable. I think that just amending the direct to make sure that follows prongs A, B, C, D very clearly is the easy remedy. But it was clear that, and I am always a proponent of attorneys conferring with each other. That I give you props for that, because that's always better than to make something up or say something that's wrong. Especially because you probably all got the hint that I'm a little bit of a stickler for the rules of evidence, and if they weren't correct, I would not accept them. Similarly, one of the attorneys objected, trying to remember who it was, but one of the attorneys objected speculation, where the correct objection was lack of personal knowledge. And if the lack of personal knowledge objection had been made, I would have sustained it, but I overruled it because they used speculation. Next thing was that for the experts, I thought that both sides could have done a much better job with focusing on the bias, because both of these experts have a ton of bias, like really bad bias. And so I think this breaking up those questions to be its own section, where it's like 3 or 4 questions all about bias, and be as specific as possible with each, so that it forces the expert to say yes to every one. If they want to qualify their own bias, that's fine, because in my opinion, all the expert is doing is digging a deeper hole if they're trying to justify their bias. But I would make that more of a section. And I also usually choose to move the bias part of my cross to the end of the cross and frame it with the signpost of, now, Dr. Cannon, I want to talk about why you're here today. Isn't it so that you work for a consulting company that only works for the defense counsel? Isn't it also true that your CEO said, insert extremely terrible statement that the CEO said there? And I think that a cross like that, where you end with the bias pocket, and this goes for both sides, would be very helpful and be more effective. My final comment is more of a, it's a small one. It's very nitpicky, but I practice in Florida, and in Florida, if you call someone by their first name without their last name also, you get fined. And that's most states as well. And so a lot of times I saw people calling either the witness who was on the stand or other witnesses like, oh, hey, Harper, or calling Genesis. That's not the case. It's Miss Martini, if you're speaking about that person. And that's just, a general courtroom decorum thing. That's not something that I care about too much, but especially if you get in front of an older judge who's judging around, which often becomes the case once you get to regionals. That was something that when I was competing, I messed up on, and I got a lot of flack for it. And I think it's well deserved, because I think, respect and decorum is pretty much the whole point of the mock trial practice. It's really trying to make sure to be as professional and polished as you possibly can. And with that, I would also, say that I would also recommend people read up on their case law in general. And I'm only saying this because I mentioned Harper. Merrill Dow is a good one. Davis v. Adams is a very good one. I also think that you can always use America's Best Cookie versus International House of Waffle, which is that the witness who's on the stand, their statements are still hearsay if they're out of court being offered for the truth of the matter. There were hearsay statements today that should have been objected based on America's Best Cookie versus IHOW. And the more you practice these things, the better you get at it. I know this statement completely lacks humility, but at this point I have all of these rules, all of these case laws memorized, and that's just because I practiced it over and over and over again. Our team would do like Jeopardy night for case law and rules of evidence. That certainly helped. And reward the teammates who are working hard to get those done, because those are usually the areas where I'm either marking people up a lot and saying, wow, they really raised a good objection, or they responded to that objection very well, or I'm marking down on and saying, oh, they did not know how to answer that objection. They should have been prepared for that. So that would be my suggestion going forward. If you have any individual questions, Liam and I can stick around for 5 or so minutes, but we also know that you have a round coming up at 2 or whenever the next round starts. So please feel free to head out if you'd like to. Thank you all for your time.
Thank you so much.
Thank you very
My
much.
pleasure.
Thank you.
Thank you.
Thank you so much. All right, I'm going to turn off the live feed.
Will do.
Actually, I'm just going to leave.